Ready? 3, 2, 1, start. Brief facts of the case are that petitioner oblique plaintiff filed a suit for declaration to the effect that he being bona fide purchaser of the suit property fully mentioned in the head note of the plaint was entitled to claim its proprietary rights and nobody, including the respondents, was justified to interfere with his possession. Full stop. The said suit was contested by the respondents oblique defendants by submitting their separate written statements. Full stop. The respondents oblique defendants number 1 to 3 filed an application under Order 7, Rule 11 of CPC for rejection of the plaint before the Learned Trial Court. Full stop. The Learned Trial Court dismissed the said application wide order dated 10th February 2005. Full stop. The respondents oblique defendants number 1 to 3 preferred a revision petition against the said order and the Learned Lawyer Revisional Court oblique Additional District Judge, Bahawalnagar accepted the said revision petition wide order dated 21st September 2005. Full stop. Hence, this writ petition, the learned counsel for the petitioner has argued that both the orders passed by the two courts below are at variance, that the provisions of Order 7, Rule 11 of CPC did not apply in the instant case and that it is a settled principle of law that court has only to examine the contents of the plaint at the time of deciding the application under Order 7, Rule 11 of CPC for rejection of the plaint, that the petitioner, plaintiff, being the bona fide purchaser of the land was entitled for the decree of declaration, that the impugned order passed by the Learned Lawyer Revision Court is illegal, ineffective, void ab initio and is liable to be set aside, Conversely, the learned counsel for the respondents, defendants has supported the impugned order. Full stop. He further argued that the disputed land stood cancelled from the name of the original allottee and then the border area committee was competent to allot the said land in favour of any deserving personnel, and in this regard the jurisdiction of civil court has been specifically bared by the statute promulgated for the allotment of border area land. Full stop. He further mooted that the civil court could not adjudicate the matter when the jurisdiction of the said court is specifically bared. Full stop. Arguments. Here the record perused, full stop. The perusal of the plaint reveals that the disputed property had been allotted to Subedar Kanwar Javed Ahmed, respondent / defendant number 4, full stop. Thereafter, the respondent oblique defendant number 4 transferred the said disputed property to Mushtaq Ahmed, respondent oblique defendant number 5, through registered sale deed number 194 dated 24th April 1985, and then the suit property was alienated in favor of the plaintiff oblique petitioner wide mutation number 52 dated 18th March 1992, full stop. Now, on the strength of said transfer oblique mutation number 52, the petitioner oblique plaintiff is in occupation of disputed property as exclusive owner, full stop. The respondent oblique defendant number 2, chairman border area committee, without notice and affording opportunity of hearing to the petitioner oblique plaintiff, has cancelled the original allotment of defendant number 4 wide order dated 26 September 1998, full stop. The petitioner has challenged the said order and its implementation in the revenue record on the ground that the same is against law, without jurisdiction, ex parte, malified and collusive, which is liable to be set aside, full stop.